first. Now you can start.
Okay, sir. Okay. Welcome to all. A very good afternoon. I, Sakshi Srivastav, on the behalf of the team of LegalStix, pleased to welcome each and every one of you to the wonderful webinar on the merger and acquisition. It is one of the leading practice in the corporate world. These are the business transaction in which the ownership of the company's business organization or their operating units are transferred to the consolidated with another company or business organization. The merger and acquisition deals with several laws like Companies Act, Competition Act, Income Tax Act, Stamp Act, SEBI regulations, SEMA, and many more. To give the vast and deep knowledge of the today's topic, I feel humbled to introduce you all to our dignitary on the panel today, our guest speaker, Hartej Singh Kochar, sir. He is a great academician, authored various books on law, and published various papers on the mergers and acquisition. So we are extremely delighted and privileged with your presence. I would request to all the participants to kindly grab your pen and paper and make a brief of today's webinar. There will be a question answer round at the end of the session, the attendees can write their questions in the box or can speak also. I hope this webinar will help you learn a lot. Now, I would like to request Kochar sir to kindly illuminate us with the apprehension of today's topic. Sir, please.
Thank you, Sakshi. You were able to hear me properly?
Sir. Yes, sir.
Okay, I'll just share my screen and let me know if my PPT is visible.
Yes, sir. Screen is visible.
Okay, and just 1 second, I'll just check whether the screen is moving as well. I'm changing the slides, that's also okay?
Sir, it's moving.
Okay, great. Okay. So thank you to the LegalStix team for having me for this webinar on mergers and acquisitions. It's good that a lot of you have already joined, and I hope more of you continue to join as we progress along. Mergers and acquisitions is sort of an evergreen field that exists in the field of corporate law and provides a lot of opportunities for young lawyers as far as employment opportunities are concerned, because every major law firm has a separate division that is dedicated to mergers and acquisitions. So if you get a command or a hold over this area, you'll be well suited or well versed or well equipped to perhaps land a job somewhere in the corporate law field with one of the big law firms or even the tier 2 law firms. Before I begin with so today I'm not going to be dealing in depth with the legal framework surrounding mergers and acquisitions, because that legal framework is very, very vast and very, very nuanced as well. So that will take, if we are to go into the depths of the discourse as regards the legal framework, that will take us a lot of time to finish. So I'll just give you a overview of the topic, and hopefully we can meet again in the subsequent course that LegalStix is organizing for the mergers and acquisitions. Firstly, I'd like to take you through a successful merger, right? This merger happened between Procter & Gamble and Gillette, and the year was 2005, and the value of the merger was about $57 billion, right? Now, all of us have used, I'm sure, P&G and Gillette products. P&G has a strong presence at that time in the household and feminine care products market. It used to have products like Olay, if you remember, and Gillette is obviously a leader in men's personal care products. Now, when these two companies decided to come together and merge, they thought that there would be somewhat they would have somewhat post merger synergies that were happening, right? Somebody's raised their hand in Dheeraj Upadhyay. So if you have a question, you can put it in the chat box. I'll deal with them later. Now, these two companies, PMG and Gillette, they thought that they would have some sort of a post-merger benefit. Now, these post-merger benefits are usually categorized as something that is known as synergies, right? Now, if two entities come together, right, in the form of a merger, two things can happen. Either that merger can be successful or it can be unsuccessful, right? Now, usually when the merger is successful, it means that post-merger synergies have been recognized and capitalized on by the two entities that are coming together. So if you look at P&G and Gillette, they are basically dealing with the same sort of products, right? They are dealing in FMCG products, household care, feminine care, and one is dealing in men's personal care. So when both these companies come together, they can utilize their already existing supply chains to market the same products now even to a broader audience or a larger consumer base. They already have their own, research and development teams, marketing teams, and all these can also come together and function in a more sort of an efficient manner. And due to the merger, what can happen is that there can be an expanded global reach of a company as well. For example, if Gillette has a strong market in India and PSG does not, so you can utilize the already existing presence of Gillette in India to further your PNG products into the Indian market now, right? Now, what does this do? Once the merger comes to fruition, what we have is an increase in earnings, an increase in revenue, and ultimately the shareholders are the ones who end up benefiting as far as the merger is concerned, right? Now, this sort of a merger is a example of a related diversification, right? Because both the entities are functioning in the similar sort of domains and they've come together to utilize the synergies of that aspect. They're dealing in related product markets, household and feminine care products and men's personal care products, right? And this is an effective way of leveraging of synergy. So for example, an example of this can be Zomato and Uber Eats merging, right? That happened in India very recently. Now, they were in the same product market. They had the same sort of, business models as well. So if they merge together, they are able to utilize the synergies of that particular business to do better in that particular domain. Next up, what we have is the example of a failed merger. That is the merger between America Online and Time Warner. Now, what I want you to do is I want you to read about this merger after the webinar has ended. And you will come to a conclusion that sometimes it's just that two entities cannot come together and function as one, right? Now, America Online was a broadband company. It has its own web browser, web presence. It was a leading online giant of its time in the early 2000s, late 1900s and early 2000s, right? And Time Warner Group had channels. It was basically a multimedia company. It has channels such as CNN, HBO, etc., right? Now, one was dealing in traditional media assets, that is Time Warner, and the other one was dealing in internet services, that is America Online. Now, both these companies, when they decided to come together, it resulted in a disaster for the shareholders. Why? Because they were not able to function properly when they came together. Why was this? This was because they failed to realize synergies. There were no synergies that existed. Why? Because if you look at both the domains in which these companies are functioning, one is a traditional media company having TV channels, etc., movie business. The other one is an internet company, right? They're actually sort of at that time competing with each other for the space, right? But here they've decided to come together, and as a result of which they're not able to basically further their goals of doing well in their respective businesses, right? Also, this is a great example of how there can be cultural incongruences between two companies. if you look at Time Warner, it's an old company, right? It has a hierarchical manner of functioning, and decisions that are taken in Time Warner are taken in a very phased manner. So there's a lot of thought given to decision making. There's a lot of bureaucratic framework that is involved. Whereas America Online was a traditional tech startup where people were not really that much into hierarchy. They were not really that much into the delay of decision making. They were wanting quick decision making to be done. So when these two sort of different management styles come together after a merger, that can cause a lot of problems as far as the functioning of the company itself is concerned. And as a result of which, the potential synergies that you want to realize for that particular company, they cannot be leveraged, right? And this merger is a perfect example of how there have been missteps in post-merger integration, right? So as far as the merger process was concerned, went relatively smoothly. But when you wanted to integrate both the companies, that is AOL and Time Warner together, because of the problems that existed as to the managerial styles and the types of businesses that these two companies were in, they were not able to get some sort of synergies in place, right? They were not able to get synergies in place. I have shared a link in this PPT as to a New York Times article that I want you guys to read. I'll share the PPT with you. And it tells you as to why there were problems as far as the culture is concerned and why this merger essentially failed, right? Now we come to the basic understanding of what is a merger. Can anyone in the Q&A section tell me what is their understanding of a merger and what is their understanding of an acquisition? Or if anybody wants to speak, that will also be great. I'll just give you 1 minute, figure out what is a merger, what is an acquisition. Just put it in the Q&A box or the chat box, whatever is convenient.
So may I just speak?
Yes, please do.
So, merger, what I think is that in merger, two entities merge together and one cease to exist. So two entities are merged and one of them ceases to exist. But in acquisition, one entity acquires the other, but both entities still exist. And that's also.
Okay, anybody else who wants to give their perspective? Somebody asked me to share the link. I'll just do that as well in the chat box so that you can read it.
Can I say something, please?
Yes, please do. Please do.
Okay, now the question what you asked is, what do you mean by a merger? Am I right? Or
Yes.
okay, I'll just give an example first, then come to an understanding.
Sure.
I would like to cite the Vodafone Idea merger.
Okay.
Now, Jio was up in full force. So competition was up in full force, giving some very attractive offers, leading to drain out of subscribers from both the entities. So due to which they were losing ground and their financials also were dented. And the Jio was actually giving a very, very attractive offering in terms of free subscription. So that impacted, and due to which both of them thought that, okay, fine, we have ceded ground. You are good in one area, I am good in some other area. Let us merge and let us take on geos together.
Yes,
How to
that's a good example. So sometimes what happens is that mergers are necessitated by the business environment that you're functioning in. So if a new competitor, in this case like Geo, came into the picture, it basically undercut everybody on costs, and as a result of which, the existing sort of customer base that these companies had was not enough, or the existing sort of size that they had was not enough to remain relevant in the market. So, and obviously these companies had lost a lot of money also during the spectrum auctions as well, and the subsequent cancellations. So the business environment necessitated that these two companies, Vodafone and Idea, come together to be somewhat of a potent competitor to the new market player who'd come in and corner the market, right? So that is also a very good sort of an example that was given. Now, if we look at the concept of a merger, right, it is usually mentioned in the cases of mergers and amalgamations are two words that are used together, right? Mostly in law. If we look at these two terms, one is merger, the other one is amalgamation. They're not actually defined anywhere under the law, right? And if you look at the Indian law, they are used interchangeably at most places, right? So there is no clear-cut definition that you will find anywhere as to what is a merger or what is an amalgamation. All under the Companies Act, however, there are two types of mergers that are envisaged, right? One is a merger by absorption, and the other one is a merger by formation of a new company, right? So what is a merger by absorption, right? Merger by absorption simply means that, let's just say A and B decide to merge, right? Company A and company B decide to merge together, and all that remains after the merger is company B, right? So we have basically extinguished company A's identity, and that has been absorbed by company B, right? So that is merger by absorption in a layman terms language, right? Other one can be merger by formation of a new company, right? A new company can mean that you incorporate a new company, right? And you transfer the assets and the liabilities of both the existing companies to that particular company, and that can be merger by formation of a new company, wherein a whole new entity is created, right? So these are the two things that are there. But in layman's term, if you want to understand, a merger is basically when two entities come together, and basically two separate entities combine together to form a new organization. So there is a new organization that is formed. However, that new organization, right, can take the form of a already existing company, like it happened when company B remained, or a wholly new entity can be created, such as company AB. If A and B decide to come together and merge, they decide to create a new company called AB, right? So that is a merger by creation of a new company, or a formation of a new company. Now, the type of merger or the type of deal that you want to undertake depends upon the business realities and the brand values, obviously, right? For example, if Instagram or Facebook rather is acquiring, or it wants to merge with a relatively unknown tech startup, right? There will be probably no need for them to form a new company, and they will just acquire the already existing company, and that will be subsumed within the vast sort of business entity that is Facebook, right? But if, let's just say, Facebook and, for example, hypothetically, Google want to merge together, right? Facebook also has its brand value, Google also has its own brand value. So it would not be proper that, after the merger, just Facebook remains or just Google remains. So they might want to create a structure wherein they have somewhat both Facebook and Google remaining. They could rename they could form a new company called Facebook and Google, or Google Facebook, right? So that is a merger as to how it will happen in the formation of a new company. Now, an example of a merger is the merger that happened between Procter and Gamble and Gillette, right? Both these two entities came together. Usually what will happen is that in a merger, there's a long convoluted process which I'll come to when we do the legal framework of the merger, right? It is substantially different from what an acquisition is. Now, an acquisition can take two parts, right? Or can be conducted in two manners, right? Let's just say I have a company A and you have a company B. I come to you and I ask for a 50% stake in your company, right? That is also an acquisition. That's an acquisition of shares, right? That's an acquisition of shares, right? Now, in this scenario, you as the other shareholder might have certain rights that give you control over the entity. I might be just coming in to purchase certain shares of your entity. I might not be getting any controlling rights in your entity. So an acquisition can happen when you acquire a substantial chunk of shareholding or a limited, even 1%, 2% stake. If you acquire another entity, that is also an acquisition. However, when we talk about mergers and acquisitions, we usually refer to acquisitions in a sort of a framework where the complete control of one entity is changing hands to the other entity. So I am coming in and acquiring 100% of the equity that you guys have. And as a result of which I can effectively control the other entity. That is a acquisition, right? For example, what happened in the case of Facebook acquiring WhatsApp and Facebook acquiring Instagram, right? Facebook came in, they acquired 100% equity stake in WhatsApp, right? Left a little bit for the founders of WhatsApp also, not 100% exactly, but a substantial chunk. So essentially what happened is that although WhatsApp remained as an independent entity and continues to function as an independent entity, the control of WhatsApp due to the shareholding being acquired by Facebook now rests with Facebook, right? So that is an example of an acquisition. Similarly, when Google acquired YouTube, right? YouTube continues to function as a separate entity, right? It has its own CEO also, right? But ultimately, who owns the shares of this company called YouTube, right? It was Google, right? So they acquired the other company, but there were no merger happening as such, right? There was no merger happening as such. Now, this is the differentiation that exists between mergers and acquisitions. Essentially, a merger is when two entities decide to fuse their operations together in some sort of manner, right? Or fuse their existence together in some sort of a manner, wherein an acquisition, it usually happens when you acquire the stake of other companies. That is an acquisition. This stake acquisition can be 1%, 2%, or even 100%, right? And as a result of which you usually get a control over the affairs of the other company. That is an acquisition. And when you acquire control over the stake of another entity, that is usually called as a takeover. You have successfully taken over control of the other entity. Any doubts till now?
No, please.
One doubt I had, sir.
Yes.
So I have read that acquisition can never be 100%. I mean, it can be like 99%. So 1% has to be with any other entity, but acquisition cannot be, 100. One entity cannot take entire 100% stake in acquisition. So is this right? I mean,
that to an extent is correct, because if you look at the Companies Act, right, it requires that even private companies have a minimum of 2 shareholders, right, or subscribers, right? But the fact is that if you look at usually what happens in an acquisition is that when one company acquires another company, they will end up creating it as a wholly owned subsidiary of sorts. And in that scenario, you can have 100% shareholding with the other shareholding being actually a beneficial owner for somebody else. So 100% shareholding can be there. You just have to tweak the documentation a little bit.
okay, sir. Okay. Thank you.
Yeah. So for example, I can be one shareholder and you can be the other shareholder, right? But you hold the shares on behalf of me, right? And or on behalf of the company itself. So you do you're getting by the regulatory loophole that you require two shareholders. So you'll be the one shareholder, but if you look at it, actually you're only holding that share on behalf of me, right? So this is how we can get by that sort of problem that you mentioned. Okay, if there are no other questions, I'd like to move on. Now, this is an example that I have on screen of the merger between HDFC Bank and Centurion Bank of Punjab, right? This happened in the year 2008 and the value was approximately $2.4 billion. And if you look at the strategic alignment of the merger, you look at HDFC Bank, right? It's an established player in banking services in India already. And the Centurion Bank of Punjab has a presence in northern India, right? And the SME sector. Now, if these two entities came together, this is an example of a successful merger again. What happens? You get an expanded consumer base, you get an enhanced network of branches. You can also get diversified services. Your Centurion Bank of Punjab might not be offering all the services that HDFC Bank offers. So now when Centurion Bank of Punjab merges with HDFC Bank, the consumers of Centurion Bank of Punjab or the account holders of Centurion Bank of Punjab would get some sort of a benefit by access to the improved services and the diversified services that HDFC Bank might have to offer, right? And as a result of this, you can also improve your market share. You can enhance your asset base. Banks usually undertake these activities to sometimes get rid of or to improve their balance sheets also, right? In case you have a lot of non-performing assets or a lot of write-offs, you can merge with a bank that is relatively stable or steady. And as a result of it, your combined balance sheet starts to look better, right? Also, this is an example of a consolidation that happens in the financial sector a lot. And if you look at the post-merger integration in these sort of circumstances, it's very simple, right? Because all you have to do in most cases is just rename the bank branches. Centurion Bank of Punjab bank branches renamed to the HDFC Bank. You give them the new account numbers and new documentation and the new training to the employees as to the culture and the provisions of services that the HDFC Bank has to offer to its consumer base, and you're good to go, right? However, there's a regulatory hurdle here that in cases of bank mergers, you require RBI approval, right? And that is a little bit difficult to come. Now, if you look at reasons for mergers, right? Mostly the reasons for mergers are that you want some sort of an increased market share or you want to achieve economies of scale, right? Or you want to diversify your business. Or for example, you might want certain access to technology that you do not actually possess on your own. For example, if you look at the Facebook Instagram merger or the Facebook WhatsApp merger, that falls under this particular category, right? WhatsApp was a messaging service that Facebook obviously did not have, and they wanted to diversify their products and also get access to the data that people are talking about on their WhatsApp chats to give you targeted ads as far as your Instagram and Facebook are concerned. So when you merge for that aspect, that can also be a very good reason to merge. If you look at BlackBerry, the company essentially failed, right, when the BlackBerry revolution ended, and it was overtaken by Android and iOS devices. But the fact that it had a lot of patents made it still a viable company, and it was purchased, I think, for about $6 or $7 billion because it had some IPRs, right? So that is also one of the reasons as to why you can go in for a merger. Sometimes you can also get tax benefits and you can also get some sort of vertical integration in the supply chain that can be really, really useful. For example, let's just say that I own a pizza shop, right? And or a pizza delivery chain, right? Or what is the most sort of important ingredient that I need? I need cheese and I need flour, right? So if I am a big enough company as far as my pizza distribution business is concerned, I can simply go and acquire the person who supplies me flour or this person who supplies me cheese And by this way, I can be, guaranteed that there will not be any supply chain disruptions that I'll ever face in the future, or my competitors might not be able to undercut me as far as pricing is concerned and take away, my suppliers for themselves, right? So these are also reasons as to why entities like to merge. And a reason for an acquisition might be that you want some sort of a quick exact expansion into a new sector, right? An acquisition is simple. It is just an acquisition of shares into another company. All you need to do is just buy stake into another company, and that's an acquisition complete. And you are able to control the activities of the other entity, and you've basically expanded into a new sector. And sometimes it can also be done to eliminate competition. A good example, again, like I mentioned earlier, would be the Zomato Uber Eats acquisition, right? So Zomato was initially competing with Uber Eats, but Uber Eats was, not surviving in the Indian market because it came in a little bit late and it was not very popular, right? So what Zomato did, it simply acquired Uber Eats. It was a competitor, but yeah, that helped to remove the competition also. Uh, Sometimes you can utilize it to acquire resources like IPRs and technologies, like I already mentioned. And sometimes it also brings upon cost savings, like through consolidation, you can get uh, economies of scale, and there can be strategic realignments as well, right? For example, if you're wanting to adapt to changing trends in the industry or changing consumer preferences, you can simply acquire another entity to cater to that changing industry trend or industry preferences, right? So these are the reasons for acquisitions that we have. Any doubts, problems till now? Okay. Uh, the process of acquisition, somebody has asked me what is the process of acquisition. The process of acquisition actually depends, right? It's usually just a share subscription agreement or a share purchase agreement that you need to sign with the other company, and you are able to acquire shares of the other entity, and there's a change in the uh, you know uh, register that the company has to maintain as far as member is concerned, and that's an acquisition. Sometimes you might need to go to the court also, and in case of public companies, you need to comply with SEBI regulations. So that is the process of acquisition, right? And there are specific SEBI rules related to that as far as the public companies are concerned. For example, the SEBI acquisition of shares in the takeover code that exists, SAST regulations, right? So yeah, I hope that answers your question. If you look at the regulatory framework for mergers and acquisitions in India, mainly it is governed by the Companies Act because it tells you the process that you have to follow. So section 232 about 237 onwards deals with the regulatory framework that exists as far as mergers and acquisitions is concerned. It's basically a tribunal driven process, NCLT driven process, wherein both the companies have to, approach the tribunal with the relative requisite consents of their creditors as well as shareholders. And the tribunal ultimately orders the meetings of the shareholders and the creditors. And when the meeting is conducted, they have to put their remarks, and the company has to take those into consideration. And when it does so, a resolution is needed to be passed in the board meetings and the shareholder meetings, and ultimately the tribunal says yes to the mergers process, right? Then you have the Indian Contract Act as well. So, for example, if a share purchase agreement or a share subscription agreement is being signed, or in case certain deals have certain, non-disclosure agreements clauses that are there till the time the deal is not completed. So all that is governed by the Indian Contracts Act because they're essentially contractual frameworks, right? Any share purchase, any sort of stake purchase, or any transfer of shares, it's all contractual in nature. If I am a company, so I'll tell you what happens in cases of mergers, right? Uh, let's just say that uh, I am a company A and there's a company B, right? Sorry, I am a shareholder in company A and there's a company B, right? Now, what will usually happen is that when these two become one entity, and let's just say company AB, both the shareholders of these companies will be given certain stake in the new company that is formed, right? That will be decided on a share exchange basis or a share ratio that is calculated. So, for example, if I, as a shareholder of A, had 5 shares in company A, I might be given only 1 share in the new sort of AB with company that is formed after the merger, right? So that is another sort of a long drawn process as to how that is calculated. So we will not go into that, but yeah, that is how it works. And then there is a specific relief act for remedies in cases of breach of contract. Here, in case merger talks break down, you can provide for a compensation also to the other party that you invited us to deal, and the deal did not go through, but we spent a significant amount of resources into the deal, and as a result of which we paid our lawyers, consultants, etc. So they can ask for some sort of a compensation. And then there is obviously the Income Tax Act that provides us to the tax considerations for M&A. Sometimes the double taxation avoidance treaties also become important because you might be having some sort of cross-border elements or cross-border companies that are involved in a particular M&A transaction. Then there is the Competition Act as well. This particular law is very, very important to prevent monopolization in a company, in a field, right? To prevent monopolization in a field. Why is that? Let's just say tomorrow Ola and Uber decide to merge, right? Or Swiggy and Zomato decide to merge. What will happen is, that we will create one sort of giant in that particular business or one sort of product market, and that one sort of giant will be having monopoly power in the business, and that can be bad for us, the consumers, right? So the Competition Commission of India's domain is to basically look at that fact that whenever mergers, amalgamations, or acquisitions are happening, that does not result in any sort of adverse effect on competition in the market, right? So before the NCLT clears your merger, it will require your consent to be given by the requisite sectoral regulator. For example, if two electricity companies are merging, then you need the electricity regulator to sign off on it. If Ola, Uber, Swiggy, Zomato are merging, then the CCI will need to, Competition Commission of India will need to sign off on it, right? Because you need that sort of go ahead that this will not be detrimental to the market as well as the consumers, right? Then we have the Foreign Exchange Regulation Acts, because they regulate the kind of foreign investment and foreign exchange that can come into the country. And then you have certain foreign direct investment policy circulars and state and central government regulations also under FEMA that can be passed, because if you remember, very recently we had barred any sort of investment coming into the country from our bordering countries, China, Pakistan, Afghanistan, etc. So those are sort of fetters that are imposed on mergers activity as far as these countries are concerned. So if I want to, perhaps a Pakistani company or a Chinese company wants to acquire me, then by virtue of the fact that the government has issued these guidelines, that cannot be done, right? But if it is somebody in the USA who wants to acquire an Indian company, there's no problem, because that has not been prohibited by the law. And in certain in case of cross-border mergers happening, you need the RBI consent also, that is given under the Companies Act itself. And that is because foreign exchange will either be coming into the country or going out of the country, and that transaction needs to be scrutinized because it might violate laws, or you might be doing some sort of money laundering through that process also. So that is regulated. And obviously there'll be some sort of central and state government labor legislation, because most often than not, mergers result in some sort of job losses as well. And two entities come together, they want to do away with the multiplicity of operations. So some people might end up losing jobs. Usually there'll be workers working somewhere in some plants, and obviously the labor law needs to be complied with. And then we have these SEBI regulations for listed entities that are there. These are there so that to protect the investor, right? If you look at the role of SEBI in general, it is to protect the investor only. It is to protect the investor and to make sure that the markets are running properly through disclosures, through proper processes that need to be followed. So for public companies and especially listed companies, there's a whole other gamut of legislation that exists under the SEBI regulations that you need to comply with. They even regulate the amount of shareholding you can purchase in a company at a time. And in case you want to acquire 100% of a company, then you perhaps will have to delist it by following the delisting regulations. So it is quite a vast array of regulations that the SEBI itself has. So this is the regulatory framework for M&A in India. We will not be able to go into the details of this right now, because obviously each of these separate heads is a separate webinar in their own right? And obviously that cannot be done in just the limited amount of time that we have here. If we look at the modes of acquisitions or in the Indian market, like I said, that mergers and amalgamations are mostly code-driven processes and they require NCLT approval. In cases of certain companies, small companies, for example, fast track mergers are also available. In case you want your wholly owned subsidiary to merge with the parent company, then also you can utilize the provisions of the fast track merger, right? And in case you want to come together and function, for example, let's just say there's a company that has expertise in road building or highway building, but it does not have the requisite money to do so. A financing entity can be become its joint venture partner, right? It can become its joint venture partner. One can bring in the expertise, the other one can bring the capital, and they can take on a project together. So that will technically not be a merger, not be an amalgamation, not be an acquisition, but it will just be a joint venture. It is something that is also there in this field that is really popular, especially in public-private partnerships, right? Wherein the government might work with a private entity together to build a road or a highway or something like that. And the government might have 40% of the stake, the private company might have 60% of the stake, and both of them might be coming together to have a joint venture. And like I said already, there are a lot of regulations as far as the SEBI is concerned. Now, one of the most important aspects while planning a merger, right, is something known as due diligence, right? Before I proceed further, do you have any doubts or any questions that I can take? Because this is the last topic that I'll be covering, the due diligence part. Anybody wants to?
Sir, there are questions in Q&A box.
Yes. Yes. So one question says that what is the compensation as far as acquisition is concerned? So let's just say that Facebook is acquiring WhatsApp, right? And as a result of which, Facebook will value WhatsApp to a certain degree. Yeah, I think the deal was around $19 billion at that time, right? So if Facebook is acquiring WhatsApp and WhatsApp has been valued at $19 billion, then the compensation that will be there in an acquisition is simply the $19 billion divided by the number of shares that WhatsApp has, right? Or to put it in an easy term, let's just say that I value your company for 1,000 rupees, right? And you have 1,000 shares in your company. So for every share, I would need to pay 1 rupee, right? That is the valuation in an acquisition. So if I want to acquire your company, I will need to pay you 1 rupee per share to buy your company, right? So there's no compensation as such in an acquisition. It's just the valuation that is there, because acquisition happens by way of acquisition of stock, right? So you need to pay money as far as the stock acquisition is concerned. Similarly, if I value your company at 5,000 rupees, right, and you have 1,000 shares, For every share, I would need to pay 5 rupees, right? So this is how you value your company. Now, the valuation usually is done by financial analysts and investment bankers. Today, your company might be just at 1,000 rupees of value, but I see some future potential that is going to be 10,000 or 12,000. And you as the owner also might know that your company has this sort of a potential, so that requires the negotiation between the two entities, and we might settle the deal at 7 or 8,000 rupees, right? So this is how an acquisition happens, right? Now, the next part that I'm going to be dealing with is a very important process that happens in mergers and acquisitions, or something that is needed to be done in mergers and acquisitions. And this is also a very good sort of an area for legal professionals, that is the due diligence, right? Now, when you are hired as a person who is going to carry out, or you're working in a M&A deal, you're to evaluate all the risks and assess the asset qualities and ensure all the legal compliances are in place for your clients, right? Now, there are a lot of due diligence due diligences that are involved, right? There is the financial due diligence, right? You try and review the balance sheet, income statements, cash flow statements, what is the amount of debt the company has, right? Because all this will impact your valuation of the company. All this will impact the valuation of a company. Also, sometimes the companies might be lying in their balance sheets, right? They might be overinflating their sales, or understating the debt that they have, or there might be some sort of accounting chicanery that they have done in the balance sheets to present a very rosy picture, but it might not be the case in actuality, right? Then you do your legal due diligence. You see whether all the contracts are in place, IPR is in place. Are there any lawsuits that are going on against your company, that after the merger, in case some compensation is to be paid out, it will be paid out from your pocket, right? Then the market due diligence, whether you're going to acquire the company that will actually help you in that particular market or not, right? Whether it has a loyal customer base, what is the competition levels in the market, what is actually the size of the company, what is the market share of the company, all those things. So whether the company that is there is complying with all the local laws, state laws. In case of India, obviously mostly you have to comply with central laws, right? And after that, there's obviously environmental due diligence, social due diligence, wherein you check whether the environmental impact and the social responsibilities are being followed by the business. You try and validate whether the assets that the company actually claims that they have, they are actually in place, right? So you do validation of property, machinery, and inventory. And obviously you try and identify whether there will be any future liabilities or any sort of future contractual obligations that the company might have to pay up for. And when you are finished with this due diligence, you will actually come up with the finalized deal structure, the pricing, and the contractual terms that you will have between the two parties, right? Now, due diligence, obviously, once it begins under a NDA, right? A non-disclosure agreement, because if I say that I have an interest in buying your company, I can utilize that opportunity of conducting due diligence by going through your records to do some business snooping as well, right? I can go into your client list, see who are your suppliers, who's, what is your future course of action, and then I can get that information and plan accordingly for my business, right? Now, that would obviously be wrong. So to plug that sort of loophole, what we do is we negotiate due diligence through non-disclosure agreements, and there are also fees that are involved in case the deal does not go through, right? So for example, if I come in to your company with an intention to buy and everything seems okay and I still don't go ahead with the deal, then perhaps I will need to pay you a certain sum of money for the time that you have invested in the deal, right? So NDAs and break fees are a part of due diligence as well. Let's just look at a case study wherein there was a due diligence failure, right? So Microsoft acquired Nokia, right? Now Nokia once was a leader in the mobile phone market, and subsequently it was struggling with competitors such as Apple and Samsung, because Apple was producing its own iOS devices, Samsung producing its own, Android based devices. Now Microsoft thought that, remember the time when a Microsoft phone came into the market as well with its own operating system. So Microsoft thought that when they acquire Nokia, Nokia has hardware capability, we'll put in our software for the mobile phones in their devices, and we will be able to compete with Android and iOS platforms, right? Now, obviously, these guys at Microsoft, they failed to evaluate the competitive nature of the market, right? And they overlooked the dominance that Android and iOS actually had in the market. And it was very difficult for them to actually gain a significant market share. And subsequently, this acquisition did not really align with the rapid shifts that were taking place in the smartphone market, right? And the consumer preferences as well. The Windows smartphones that were launched, they did not satisfy the consumers. Not even a lot of developers came on board to develop apps for them. And as a result, what ultimately happened was in 2015, Microsoft announced the write-off of $7.6 billion related to the Nokia acquisition. And the write-off actually exceeded the original acquisition cost of $7.2 billion, right? So as a result of the acquisition of Nokia and the subsequent write-off, which was in excess of the acquisition cost, Microsoft actually lost money when they invested in the Nokia smartphone business, and as a result of which they had to now, since that line of business did not work, they had to lay off employees. A lot of people lost their jobs, and that also resulted in a significant shift in Microsoft's strategy now, because they moved to cloud computing and providing software solutions only rather than getting into hardware as far as smartphones are concerned. And even till now, they have not really ventured in again into the smartphone market, right? So, like I said, the learning points from this are that you need to analyze in depth before you pursue a M&A deal as to what are the incentives and what are the reasons behind getting into that deal, and there has to be some sort of a strategic alignment between the acquiring and the acquired entity, right? And I hope that is all. I've finished my presentation for today. I tried to give a lot of examples to you guys so that you learn through that, and it was a little bit low on the law because that gets a little bit boring, if I may say so. But yeah, I hope you like the presentation.
Thank you so much, sir, for sharing such a
Good knowledge with us. Surely the participants have got enlightened. Now we'll proceed to the question answer round. Those participants who have questions, put their questions on Q&A box, and also unmute. Yes, Samdipta, I think.
Yes. Thank you, Mane, for such an enlightening session. Got around 3 or 4 questions. May I ask?
Yes, please.
I'll start with number 1. Will the 10 to 12 hours be enough for such a vast subject basis the timelines which I was able to see through the advertisement?
If we actually look at 10 to 12 hours, I'll have to conduct the sessions a little bit longer than that. I was having a chat with Akanksha related to that as well. I don't think it's written 1 hour each, but I think we'll have to go to 1 hour 20 minutes or 30 minutes. That's what I think.
That was my picky thing, which was
that's at my end. I'll take care of that.
Absolutely. Thanks a lot. My second question is, during the classes, will a checklist be provided and a case study be practically discussed during classes?
Yes. I'll send across certain reading materials. In fact, there's a good book on case studies related to mergers and acquisitions as well, right? And I'll try to share the financial as well as the legal regulatory standpoints from those case studies so as to make you better understand uh, the things that we are going to be dealing with.
Okay, thanks a lot. Now, two more questions relating to the knowledge part.
Yes.
Like, I just wanted to know, whenever we say due diligence, so it means effectively checking the other party's information, right?
Yes. Yes.
In plain and simple layman's language.
Yes.
So, how does one ascertain the completeness of the information put forward by the other party? Means, for a listed company point of view, I can agree that it might have to comply to certain norms, and it might be present in the, what should I call, the notes to accounts, certain information which can be used during the due diligence, right? But for a non-listed company or an unlisted company, how does one ensure? Means it can be so, just hypothetically speaking, that the other party suppresses something. Means how will that, means just trying to understand how will you
Even
find
in
out?
private companies, there is a lot, there are requirements that exist as far as regulatory compliance that is undertaken. And this due diligence is not a very sort of perfunctory sort of a due diligence that is carried out. It's a very in-depth due diligence. So in case you say that you had sales worth 10 lakh rupees, the persons who are conducting the due diligence will ask you to actually furnish those invoices, right? So as to make sure that you are not trying to suppress any information, although that can happen. But then again, there are remedies under civil law and criminal law for that. You can ask for compensation later on, or in case that is discovered during the deal, you can simply walk away from the deal.
Now, my question is, say for example, I am a party A, I am desperate to get party B. Now, although my team has checked for the due diligence, it might be so that from the contingent liability point of view, it might not appear in the books of accounts as of now. So it might be a future hit. So therein, how does one check? Means I was just inquiring from the point of view of money, what you call ring fencing, so that everything is properly done in a watertight manner.
If you look at something that might come up in the future, it's mostly a question of what might happen. You try and figure it out, because I remember there was this one case that was there in the United States. One company had acquired another company, and they had thought that even if damages are awarded in that particular case, it will just be around an X amount, right? But and they had factored that into the valuation that they had given to the other party. But the damages ultimately were 100 times what was thought by the company, right? And as a result of which, and this happened 5 or 6 years down the line, because there was a jury award, and they awarded millions and millions of dollars in compensation, which was not factored into the deal. Now, either you can have some sort of insurance for that, right? Or you simply take a hit later on. But mostly you try to factor that into the deal itself. You try to negotiate, you try to reduce the value of the deal on the basis of any sort of contingent liabilities that you might need to pay for later on.
Yes, because usually, means just my basic arithmetical understanding is that if I'm having a good sales or turnover, and I intend to display that during the course of our meeting, and in fact there is some litigation at some point which will give a hit and make us a dent on those financials later on, so the valuation obviously gets impacted. Am I right?
Yes, valuation gets impacted.
So,
Even if your let's just say patents are going to expire, or they'll come out into the public domain, or if you're if you're in the oil and gas sector, and there are certain changes that are regulatory changes that are going to come about. And for example, a move to renewable energy. All these are factors that impact valuation.
Okay. So last question,
Yes.
just again from the knowledge point of view, are court-related merger orders, do they bring any sort of tax relief? That was just a rumor which I heard.
In some cases they might, or in some cases they might. Because if you acquire a distressed company in that sort of scenario, you might be able to get certain tax breaks.
Okay. Now, say for example,
If you acquire a company in under the IBC process, so now that company is already suffering losses and ultimately have to pay a valuation for it, and you have to shell out money, right? And you, as a result of which, when you have a consolidated balance sheet after the acquisition, there are no net gains that you have to pay for, right? That company was having losses, and as a result of which, you can take advantage of that in your own taxation and balance sheet related issues.
okay. So one more aspect.
Although
during the
mostly
checklist-
if you acquire the Vodafone case is related to this as well. So we will discuss it in the sessions that happen. And the subsequent law was also changed where the government, this obviously depends on the regulatory framework also, where if the government can want you to give some sort of a tax, and it can bring out ordinances also, like it did in the Vodafone case.
at International Court of Justice issue.
Yes.
Okay, wherein they waived off. They did not actually pursue it post that order from the International Court of Justice, and they came out with some kind of notification that if you give a request, we'll consider it without payment of any interest, and we'll drop the
It
case.
was a cross-border deal, so there were some sort of capital gains issue that was there.
Okay, so now my question is, from another point, GST point is also there, right?
Yes, GST point is also there, because let's just say that, oh, okay, so not in all cases you might not be acquiring, let's just say, shares, or in case you're acquiring shares and all, that's a separate thing. But let's just say you're acquiring simply assets, or you're acquiring simply the IPR related, you're acquiring IPRs, or you're indulging in some sort of a slump sale of a business, right?
Right.
Slump sale means you sell a part of it that is severable. For example, if you have a shoe making plant and a cement making plant, you just sell off the shoe making plant to somebody else. So when you acquire that shoe making business in that sort of scenario, you are actually acquiring an asset, right? You're not acquiring shares. So in that circumstances, obviously the consideration will involve GST as well.
So that was another angle I was thinking about. Anyway, thank you
But
very much.
Yes, that does not actually come under the purview of strictly a merger or an acquisition of shares. Although the term acquisition is very broad, that can include acquisition of shares, assets, or voting rights also. So that comes under the acquisition of assets.
Okay, yes, because effectively I do not recall that there was one case wherein slump sale is equivalent to a lump sum sale. Means whatever the stocks are, there is a lump sum valuation.
Not
and
exactly the stocks. You sell a part of your undertaking, business undertaking, mostly a sale of assets.
say a particular division, if I can.
Yes, particular
articulate it.
division. Yes. There are also rules related to that. I think Section 180 of the Companies Act talks about the slump sale. If you can look into that.
Okay. No, thanks a lot, Hartej. Thank you so very much.
Okay, no problem.
I look forward to this course. Thank
Yeah,
you.
So
Yes.
there is a question from Astha that she is the law graduate and she wants to pursue her career in M&A. So can you guide her on how she can proceed with it?
See, a simple sort of a answer would be that sometimes it becomes too late when you're a law graduate already if you want to pursue a career in M&A, but that's not a drawback, right? Even if you are a law graduate, you can still ask for internships in top tier, law firms or mid-tier law firms, you should not be afraid of interning even if you have graduated, right? Because that internship experience can land you a job later on if they are satisfied with your work. What I suggest is firstly read up on the subject matter, as much of information that you have available online. There are books that are available. You can download the books through a lot of websites as well. Since this is being recorded, I will not say where, but there are a couple of websites where you can get all the books that are there in the world for free, right? So you can do your own due diligence as far as that is concerned, and get your knowledge, preferably publish papers or blogs on the same. This is an advice that I give to every law student, is that have your own blog during the 3 or 5 years of your law school journey. Making a blog is really simple. You just require a WordPress account and simply, whatever you want to, there are interesting topics that are being discussed daily in the news, or there might be something interesting that is discussed in the classroom. You simply write a blog post on it as to what you have understood or what the law surrounding it is. And that body of work you can showcase to your potential employer, or when you're applying for an internship, you can simply give the link of your blog. And sometimes these blogs also get picked up by live law and bar and bench as well, and that gives you visibility in the field. And obviously there is LinkedIn for visibility also. So my advice would be to utilize all these avenues that are there, and preferably try for internships, right? Because if you do not come from a top tier college, these companies which actually deal a lot in the M&A business will not come for campus recruitments. I say that as a academician who's himself worked in a couple of private universities. Very difficult to bring them there because their alumni of NLUs and all are already working in these companies, and they prefer to come to their own colleges for hiring. Now, this is, I think, what you can do: try for an internship. And if you want honest advice, I will say go to a mid-tier firm and try there, because the chances of you getting selected in a mid-tier firm are slightly higher if you put out good work, because a certain chunk of the recruitment for top tier law firms is already on the basis of campus recruitment, right? And that they will go to top tier colleges. In case you want to, there are boutique firms also which advise on M&A. So do your research, apply there for internships, work there, try for a 3-month internship. I know that that will take some amount of time, and you might have to work without money also. But if you do quality work, either you get offer from them, or if you cannot, then if they don't have any space right now, all these people know each other and they can recommend you to somebody else for a job as well. So yeah, that is my advice.
Varun, you can unmute yourself and ask your question.
Yes, sir. So, sir, can you please share some sources from where we can get the knowledge about mergers and acquisition, recent mergers and acquisitions? I mean, not just the news, but the analysis of the mergers or acquisitions. I mean, in the
Okay.
news, we just used to get.
If you have access to JSTOR or Hein Online, right? A lot of times these, and in fact, try for management journals, right? Because they have an in-depth analysis of whether that merger has been successful or unsuccessful, or what were the financial considerations that were involved, right? So management journals that are there, they are a good starting point for understanding M&A deals. If you want to look at the legal framework surrounding them, these law firms like Nishit Desai and AZB and all these people, they put out handbooks and explainers regarding the same, right? And you can basically have a look at those as well.
Okay, sir. So can you explain about these management journals? I don't know what do you mean by management journals?
Okay, so are you a law student?
Yes, sir. I've graduated from the law school. Now I'm practicing currently, but I want to
Okay,
transition to corporate practice. So
okay.
that's why.
So since you're a law student, you will know that there are a lot of law journals, right, in which people write papers and publish them, right?
Right, sir.
Yeah. So similarly, we do that in legal journals where the essence is the law. We evaluate and critique the law and understand the law. Similarly, in the domain of management field, there are also journals which cater to them, right? There are economics journals which cater to the field of economics management. के लिए we have management journals. Now, in these management journals, basically people who are financial advisors, economists, they write and they analyze merger deals, right, from the perspective of financials and due diligences and the economic impact and the share value, whether that is appreciated or not. So yeah, this is what I mean by management focused journals.
Okay, okay. Thank you, sir.
Yeah.
So there is one more question from Shafi.
Can you please repeat the asset acquisition and the section which it in companies are?
I think it is section 180. Yeah, just check again. Section.
Sonali is asking that
I'm not able to hear you now. Hello.
Hello.
Yes, I'm not able to hear.
Sir,
is I'm audible now?
Yes, yes.
I lost my connection. Yes, sir. Wait. Sir, Sonali is asking, can we use Medium or LinkedIn instead of WordPress?
Yes, yes, you can use Medium also, but Medium I think requires you to have some sort of a foreign-based account. LinkedIn is also good. Both are good for publishing. But if you want the long form, I think it's a blog that is useful. So a WordPress account is better because LinkedIn has, I think, space constraints, but it has also a section wherein you can publish a blog post also. So that is there.
Sir, one more question
Yes, there
is,
is section 180 only. It's the power of the board to authorize sales of assets.
so one more question. Just
is there temporary acquisition also?
No, there's no temporary acquisition. I mean, it can become temporary. See, it's at the end of the day, if you're acquiring shares, right? So if I acquire shares in a company and then sell them off tomorrow, I might have control over that company for a single day. So you can classify that as a temporary acquisition, but usually that's not the case.
Yes, sir. So let me check all other questions.
I think we can wrap up now, Sakshi.
Yes, sir, it's late.
Yeah.
Thank you, sir, for answering all the questions graciously. So due to some reason, I am unable to start my camera. So sorry for that.
No, it's completely fine.
As we come near to the end of the webinar, on the behalf of the team of LegalStix, extend a warm and hearty thanks to Kochar sir for giving an excellent coverage to the topic and enlightening us. We all feel blessed to hear you, sir. Thank you so much. And I would also like to thank all the participants for being patient. Audience, thank you. Keep learning. Jai Hind, Jai Bharat. Thank you, sir.
Okay, thank you. Thank you all for joining.
Thank you, sir.
Thank you, Hartej, for being such a patient answerer. I really loved it. Thank you.
Thank you.